shortly here. Okay, ready when you are.
Awesome. Thank you, Alicia. Good morning, everyone. It's 9 a.m. I will call this meeting of the Committee of Adjustment hearing on today's date, September 25th, to order. My name is Barbara DeBreen, and I'm the chairperson of the Committee of Adjustment. The committee members include members of council. However, we sit at this table as the Committee of Adjustment and not as members of council. Our jurisdiction lies solely with matters of consents and minor variance applications. The secretary of the committee is Alicia Mill. This is a hearing to consider applications for minor variances and consents within the Township of Southgate and is held under the provisions of the Planning Act 1990. This hearing will be in accordance with the Provincial Planning Act, the Municipal Act, and the Township of Southgate official plan. Could I get confirmation of the agenda, a mover and seconder, please? Joan, Martin? Any additions or deletions? Any opposed? Seeing no hands, that is carried. Declaration of pecuniary interest? Seeing no hands from the committee, we are reminded we can declare it at any time should something arise. Alicia, are there any adoption of the minutes? Mover and seconder to adopt the minutes from the previous meeting. Joan? Monica? Any errors or omissions or discussion required? Any opposed? Seeing no hands, that is carried. That was from August 28th. Sorry about that. Hearing, I will ask that anyone speaking about an application to state their full name and address for the record. Please keep all remarks relevant to the consent or minor variance application before us, as the Committee of Adjustment has no jurisdiction on any other matters. Any materials submitted to the committee for viewing will remain the property of the Committee of Adjustment and will be available for public viewing in the application file and may be placed online. Please direct your remarks and questions to the chairperson of the committee. This will enable the hearing to be conducted in an organized manner. The first file is A924, Jamie and John Allen. The purpose of the minor variance is to allow construction of a dwelling on an existing lot with a 2.1 meter minimum front yard setback from Cedar Lane, 1.8 meter north side yard, and a front porch that projects 1.8 meters into the front yard. The township zoning bylaw requires a minimum front yard of 7.5 meters and a side yard of 3 meters, while section 5.1H permits a 1 meter maximum unenclosed porch projection into a required yard. The effect of the minor variance would be to reduce the required front yard by 5.4 meters and the required north side yard by 1.2 meters, while increasing the maximum porch projection into the front yard by 0.8 meters so that the detached dwelling can be built on the existing lot. The location of the subject land is Plan 815, Lot 4, subdivision of Concession 1, Egremont, Lot 4, Geographic Township of Egremont, Township of Southgate. There is no civic address assigned at this time. Alicia, is there a request for deferral or withdrawal of the application?
Yes, through the chair, we have received a request to defer the application. Pardon me. The request for deferral came through the planning consultant, Coesta, on September 23rd. And their request is to defer until the October 23rd Committee of Adjustment meeting.
I see, and Cuesta is the planner on behalf of the applicant.
That's correct.
Okay. So in this case, we would need a motion to defer or a motion to grant the deferral from the committee?
That's correct.
Oh, did you hear that? Oh, okay, we've got a delay here. So I need a mover and seconder to grant the deferral to the October Committee of Adjustment meeting. Could Monica, a seconder, please? Joan will second. Any discussion about the deferral?
Chair.
Bill?
Chair.
Yes.
Chair DeBreen, sorry to interrupt. I just wondered if there was anyone else members of the public who were here to speak, because they may not necessarily know about the request for the deferral. So I wondered if the chair could ask. If I don't see anyone, but if there is anyone that wants to speak on this, I guess it would behoove the committee to hear from them about whether they are okay with the deferral or if they have anything they want to say to you.
I'm looking at the script, Bill, and we wouldn't be able to proceed if there was a deferral or withdrawal. Right. So they could speak to the deferral, but I don't imagine that they can speak to whether they are for or against the application, because we're not actually hearing it today.
Right. Fair enough. I guess maybe to speak to the deferral then, in case they can't make the 23rd and they wanted to speak to you, that's all. Okay.
No, that's fair. Ken, you've put your camera on. Ken Mallinson, did you want to chime in on that?
Thank you, Chair DeBreen. Actually, no, you guys have figured it out. So you're good.
This is all new to us. So I will ask anyone on the online audience if they are here to speak to file A924, if they would like to speak to the deferral, us granting the deferral of the application to the October meeting. Seeing no one unmute, we can assume that everyone is fine with that, and we will, I'll call the question for granting the deferral. Any opposed? Seeing no hands, I can declare that as granted. So the decision of the Committee of Adjustment is to grant the deferral of the application to the October, did you say 23rd?
Yes, Chair, that's correct. It'll be the 23rd meeting in October.
Thank you.
October 23rd.
October 23rd meeting. Then we can move on to the next file. Thank you. We now have B724, Dennis and Jackie Groves. The purpose of the proposed consent is to transfer a 207.38 meter by 195.145 meter parcel of land to the abutting property to the south, while retaining a lot containing the existing home and accessory buildings with 195 meters frontage on Southgate Side Road 21. 202.33 meters of depth and 3.94 hectares of lot area. The effect of the consent is to reduce the subject lot by 4.04 hectares in area and add it to the abutting property to the south. A rezoning application has been submitted to address zoning of the lands resulting from the proposed consent, file C23-24. Location of the subject lands is concession 13, part lot 33, RP16R8317, Part 3, Geographic Township of Proughton, Township of Southgate, with a civic address of 212475, Southgate Side Road 21. Alicia, is there a request for deferral or withdrawal of the application?
Through the chair, there have been none received.
Seeing none or hearing none, we can proceed. May I please have clarification that the sign was posted?
Yes, through the chair, sign was posted and notice was given in accordance with the Planning Act.
Great, thank you. I will now ask our planner, I'm not sure if that's Bill or Victoria, to review all comments received and present the staff report. Who's taking that one?
Thank you, Chair DeBreen. It would be myself in this case.
Good morning again.
Good morning. Thank you for the opportunity to speak to the committee today. There were comments received from Bell, Enbridge, Hydro One, generally with no comments or concerns. Township of Southgate Public Works has asked for 3 meters road widening. The Saugeen Valley Conservation Authority and the County of Grey both reviewed the application and have no significant concerns. The county has outlined the provisions of their official plan which allow for a technical severance such as proposed here. And the Saugeen Valley Conservation Authority has noted the hazard area on the properties, but they have no objection or concerns with the proposed severance. If the chair or committee is happy, then I can move on to the staff report. Thank you. This proposed severance is a lot line adjustment to transfer 4 hectares of property. I'm going to use rounded dimensions if it's okay with the committee. 4 hectares of property from the subject lands to the abutting owner to the south. The lot line adjustment creates a 12-hectare parcel upon which makes the abutting parcel 12 hectares, and the subject parcel would be just under 4 hectares. These lands were zoned A199 some years ago, and that recognized a reduced lot frontage and reduced lot area. The lot area in question in the A199 zone is shown in the zoning review as 3.7 hectares. That's actually not correct. It's 7.9 hectares is the minimum lot area requirement. So the result of the transfer of the back portion of the lands to the abutting owner creates a deficiency in the lot area for that existing parcel, the subject lots. So the retained parcel would be just under 4 hectares in size, and it wouldn't comply with that A199. So one of the conditions of rezoning is, one of the conditions of the severance is that the lands be rezoned to recognize the reduced lot area and any other deficiencies. Section 50 sub 3 of the Planning Act basically is a stamp on the deed that would be used by the Secretary Treasurer that says that that back piece cannot be severed again without another application to the Committee of Adjustment. So it merges the back parcel to the abutting parcel to the south forever. And if they ever wanted to convey that same parcel, they'd need a severance to do that. Then the final condition recommended is all the standard conditions that may apply relating to any parkland dedication that's needed, any road widening that is requested, which is asked for by Public Works in this case. And there's normal requirements about taxes and so forth that those be resolved. The only issue in this application briefly is that in the agricultural designation, there is a provision that lot line adjustments should occur when both the receiving and sort of the benefiting and severing parcel are 40 hectares in size. There are other provisions of the official plan, township official plan, that allow for technical severances. I want to point that out to the committee. We have given more weight to the technical severance application provisions that are in the township official plan. The wording of that 40 hectare requirement that both the severed and retained and benefiting parcel be 100 acre or 40 hectare parcels is not quite clear, frankly. And because it's not in the county official plan either, and because we're dealing with existing lots that have been rezoned, we're putting more weight on the technical severance side. And so we're recommending that this severance be approved with the conditions as outlined.
Is that, are you frozen or are you done?
No, I'm good.
Oh, good. All right. That concludes
I'd be happy to answer any
report.
questions.
Awesome. Thank you. I just wanted to ask if there were any comments from the public received by you or Alicia.
Through the chair, no public comments were received on this application.
Thank you. Do any of the members of the committee have any questions? I see no hands. Are there any others in attendance that would like to speak in support of the application? You can unmute Ron Davidson. Hello, Ron. Good morning.
Good morning, Madam Chair. Can you hear me okay?
I sure can.
Perfect. I shall be very brief.
I actually missed that part on the script there. I apologize, Ron. I should have asked if the applicant was present and would they like to state their case.
I
Go ahead.
get missed a lot. It's a story of my life. I shall be very brief. I'm the planning consultant that's filed the application, and I'm representing Dennis and Jackie Groves. As you heard from Bill, this is a lot line adjustment, and it really should be treated as a very straightforward matter. We went through pre-consultation with township staff and the Grey County planning staff before we filed the application, and there weren't really any issues. What is happening here is when the Groves bought the property a number of years ago, they realized they bought a lot of land, and prior to them owning it, the backlands were in fact farmed by an area farmer, but they haven't been in a couple of years. So Mr. Groves every Saturday morning, I guess, goes out and mows the back 4 hectares of land, or quite a bit of it anyways, and as you can imagine, that's a lot of work. The neighbor next door, the property next door, is vacant, and the new Mennonite owner is going to be, I think he's building a house, but he's going to be farming some of the lands, and he wants to farm the back 4 hectares of the Groves property. It's not going to end up being on its own a viable farming operation, but it is obviously beneficial to that neighbor that wants to farm the land. So that's why they're doing this lot line adjustment. If these, as Bill was alluding to, these lots today would not be allowed. If somebody came along and wanted to sever off 2 lots of basically any size under 40 hectares, the official plans for both the county and the township would say, no, you can't do that. But that ship sailed. We have 2 lots. The idea of adding or taking away the agricultural land, or lands that can be used for agricultural purposes, and adding it to an abutting farm property actually makes a whole lot of sense. I dare say we're actually coming closer to conforming with the official plan, or the intent of the official plan, than the existing situation today. So that makes, in my mind, there's a whole lot of merit to that, and I think all the planners who were involved in pre-consultation get that. Yes, there is a zoning bylaw amendment requirements, and in a few hours, council will be dealing with that at a public meeting at 1 o'clock. That's it for my presentation. Other than, Madam Chair, if I could ask through you, just a question about the road widening. That I don't think that came up before, and my only question is, I'm not questioning the need for it. I just wonder out loud here, is that something that the township is doing across the board with all consent applications? Thank you.
Thank you. I'll refer over to staff. Bill, would you like to field that one?
Sure, I'll give it a try. It seems to be in a lot of them, as I can recall, but not all of them. So I'm not entirely sure how the public works manager is identifying those that he needs road widening on and those that he doesn't. But it does appear, I would say, in more of the applications than none not. So I don't know if Public Works Manager's in the meeting, but it was his comments that stipulated the road widening. So this is the time to ask for it, I guess. And as I recall, the side road in question is 66 feet or 20 meters in width. So yeah, that's all I can say.
Thank you. Thank you. I can also defer to the clerk, but we have yes, go ahead, Lindsay.
Morning. Thanks, Chair Dobrin. I haven't been as involved with the committee over the last couple months when we've had Bill and Victoria, but previous it was Jim's comment was it was standard to take the 3-meter road widening if it hadn't already been taken, and bring that forward to the committee. So I would say it's pretty standard. of his, like, that's his standard comment typically. If we can take it, we will.
Yes. Ron, I can speak to that. The county also, if they haven't taken a road widening, it's future. We're going to take it now just in case we're going to widen that road and upgrade that road to a higher standard. So it is standard practice to take it if it hasn't, as Lindsay has mentioned.
Yeah, thank you. Yeah, and yeah, the county's been doing that for probably 8 or 10 years now, so I'm aware of that. Just wasn't sure, and that's, you've answered my question. And if I may, just one more question on that note, though. To be clear, it applies to the retained parcel. It would not apply to the neighboring property next door that's benefiting from the lot line adjustment. Is that right, Bill or Lindsay?
I think I'm going to ask Lindsay to answer that.
Yeah.
I want to say it does because they're both involved in the file, but Lindsay or Alicia?
I see Bill took off his mute, so I'll let him take that one.
I don't believe you could apply it to the benefiting parcel. It's not the application is on for this one piece, so I do not believe they could that they could be compelled to give the road widening on the adjacent lands. But
Yeah.
you can try that as a condition, but.
And if I may, thank you for that. The reason why I asked, yeah, the county, again, for the last several years, they've been doing this. They have never, to my knowledge, I've been involved with a lot. They would not take it from the benefiting lot because that's not technically part of the consent application. Just one clarification. Thank you. I shall stop talking.
Thanks, Ron. That's no problem. That's what we're here for. So we'll go back. Are there any others in attendance that would like to speak in support of this application? Are there any others in attendance that would like to speak in opposition of the application? I'll ask the committee again if there is a requirement for further discussion. I do have a question, Bill, to your comment that the severance portion of the parcel that is being added to the abutting property, you said something about severance, a future severance of that parcel would not be able to happen. Were you referring to just the part that is being added to the abutting parcel, or are you saying that the benefiting parcel in its entirety would not be eligible for a severance in the future?
Right. Chair DeBreen, I think the answer is yes. The piece at the back would be permanently joined to the abutting parcel to the south, and they could sell the entire piece, the two joined parcels together, but they couldn't sell the back piece on its own without another severance. That's what section 50, by using I'll call it a consent stamp, but basically it's a one-time severance. So that back piece is severed once, joined to the abutting parcel, and it's forever joined to that abutting parcel. And if they want to split it back off and sell it, say, back to the Groves, then they would need another severance application to you.
And the only parcel that it could be severed and back to would be the applicant or whomever owns the property, because otherwise it would be landlocked. But it doesn't prohibit the abutting property, the benefiting property, from severing the front half of the parcel. And I know. Yeah, I guess we'll never know. We'll cross that bridge when we get to it. Literally.
Yeah. It'll be an L-shaped parcel forever, unless if they want to convey off a piece of their land, they would need another application, whatever configuration they may want to sever.
Okay, thank you. Always learning something at these meetings. Martin, you'd like to speak?
Yeah, so that's a good point that the chair brought up. So maybe down the road, the Mennonites could buy the benefiting property and make that a whole farming cluster then, being Mennonite. Not that I'm against that, but there's legal ramifications down the road. And another one, in the in the comments, I don't know if this is part of a public planning question or what, but in the comments, it says that the property is going through another application for a small farm cluster and a shop. So that comes down to the road widening again for the shop. Could you clarify what was said about the road widening for the benefiting property? Because why would they, as I said, it's standard, but why would they need that? If there's going to be a shop on the other property, then obviously there's going to be a new lane and a bigger uh, allowance for that.
Right.
And the other, if there is an ongoing application, I'm looking at the hazard map. It can be cropped, but where would they be able to put that cluster? They can put industrial and housing in hazard lands. That's a very small piece of property.
So Martin,
That is
I'm going to
something else,
stop.
isn't it?
A totally
Yeah,
different
totally
file.
different.
We have to deal with just
Yep.
what's before us today. We don't involve matters that's not before us on this agenda.
Yeah, okay. So if that road winding could be explained for the
Right.
property
Yeah.
again. So I was garbled. I couldn't hear it. So thank you.
If I may, through Chair DeBreen,
Mhm.
the road widening can only be acquired, in my opinion, from the lands that are subject of the application as a result of the consent. So the Groves would have to give the 3-meter road widening if committee approved this with a condition. The committee could not acquire it, in my opinion, off the benefiting parcel, even though it is subject to a different application. It, under the Planning Act and policy, it's not allowed to acquire road widening off in that instance. It was a minor variance application that you heard a few months ago, maybe not all that long ago, but in any event, it is separate and it is not subject to road widening, in my opinion, only the applicant's lands.
Thank you. And we got a thumbs up from Martin, so we're good to go. All right. So seeing no other hands from the committee members, I will ask for a mover and seconder to grant, refuse, or defer the application. Martin, what would you like to do?
Straightforward file, so let's grant it. I move to grant.
Move to grant. I need a seconder, please.
I'll
Joan?
second it there, Barb.
Oh, Joan got ahead of you there, Jim, but thanks. I'll get you to move the adjournment. All right, so we just have to turn my computer back on. It timed out. We have, be it resolved that the Committee of Adjustment receives staff report PL 2024-083 regarding consent file B7-24 by Dennis and Jackie Groves for 212475 Southgate Side Road 21 is received for information, and approve consent file B724 to transfer a 207.38 meter by 195.145 meter parcel to the abutting landowner and retain the lot containing a home and accessory buildings with 195 meters frontage on Southgate Side Road 21, 202.33 meters of depth and 3.94 hectares of lot area, subject to the following conditions. A, that the subject lands and abutting lot to the south be rezoned to recognize the reduced lot area and any other zoning deficiencies related to the conveyance. B, the section 50(3) of the Planning Act applies to any subsequent conveyance of the proposed severed lot. And C, standard conditions related to parkland dedication, road widening, and similar. We have a mover and seconder to grant. Any opposed? Seeing no hands, that is carried. The decision of the Committee of Adjustment is to grant the application, and the applicant shall have 2 years in which the conditions must be met. Adjournment. The notice of the decisions from today's meeting will be signed electronically by members and distributed accordingly per the Planning Act. Anyone wishing to file a notice of appeal is encouraged to seek legal advice on your appeal rights, given recent changes of the Planning Act because of Bill 185. I get a mover. Jim Ferguson will move. I need a seconder to adjourn the meeting. Martin? Monica, okay. Any opposed? We are adjourned.